The Epstein Files. Part 7. The 2008 Plea Deal. Anatomy of a Legal Collapse. In any justice system, there are moments when outcomes reveal more than intentions. Moments where procedures are followed, documents are signed, and agreements are reached, yet justice quietly disappears. The 2008 plea deal in the Jeffrey Epstein case was one such moment. This was not a dramatic courtroom trial. There were no televised arguments, no jury deliberations, no public reckoning. Instead, accountability dissolved through paperwork, private negotiations, and legal discretion exercised far from public view. This episode is not about speculation. It is about process. About how the legal system, while appearing functional, produced an outcome that would later be widely described as a failure. To understand how this happened, we must reconstruct the environment, the decisions, and the consequences, step by step. Setting the stage. By the mid-2000s, allegations against Jeffrey Epstein had already accumulated. Multiple underage girls had given statements to law enforcement. Their accounts showed consistent patterns: recruitment, exploitation, and payment. Local police investigations in Florida had gathered substantial material. By 2007, the case had moved beyond local authorities. Federal prosecutors were now involved. At this stage, the legal trajectory could have followed a familiar path: federal charges, possible trial, and public scrutiny. Instead, something else occurred. Behind closed doors, negotiations began not in courtrooms, but in offices. The Non-Prosecution Agreement. In 2008, a non-prosecution agreement, often referred to as an NPA, was finalized. Under this agreement, federal prosecutors agreed not to pursue federal charges. Epstein would plead guilty to state-level offenses. The deal would also shield potential co-conspirators from prosecution. Victims would not be notified before the agreement was signed. This type of agreement is rare, not illegal, but highly unusual in cases involving multiple victims and serious allegations. The legal justification rested on prosecutorial discretion. Prosecutors have broad authority to decide whether to bring charges, how to negotiate, and what outcomes to pursue. In theory, this flexibility exists to serve justice efficiently. In practice, it can also bypass transparency. What was avoided? Had federal charges proceeded, Epstein could have faced severe sentencing exposure, federal prison time, broader investigative reach, greater discovery of evidence. Instead, the plea deal resulted in an 18-month sentence at the state level, work release privileges, limited incarceration, no federal conviction. From a legal standpoint, the system had not broken any explicit rules. From a moral standpoint, many later argued it had failed its purpose: the exclusion of victims. Perhaps the most consequential aspect of the 2008 deal was not the sentence itself, but the process. Victims were not informed of the agreement before it was finalized. Under the Crime Victims' Rights Act, victims have the right to be notified and consulted in federal proceedings. Years later, courts would determine that this right had been violated. But at the time, the deal was already done. The people most affected by the outcome had been excluded from the decision-making process entirely. Sealed silence. The agreement itself was not immediately publicized in full. Key elements remained obscure: the scope of immunity, the reasoning behind prosecutorial decisions, the communications between defense attorneys and prosecutors. This opacity mattered. Without transparency, accountability becomes difficult, even impossible. What remains hidden cannot be challenged. The role of power. This episode is not about alleging motives. It is about recognizing context. Epstein had significant financial resources, high-profile legal representation, extensive social connections. In the justice system, access to top-tier legal defense does not guarantee outcomes, but it changes the terrain. Negotiations become complex. Risks are calculated. Institutional incentives shift. What might be pursued aggressively in one case may be settled quietly in another. This is not unique to Epstein, but the scale of the disparity would later draw national attention. Immediate aftermath. At the time, the plea deal did not trigger widespread public outrage. The case faded from national focus. Epstein served his sentence under conditions that allowed significant freedom of movement. The system, on paper, had closed the case. But closure without accountability does not end a story. It delays it. Long-term consequences. More than a decade later, the consequences of the 2008 deal would resurface. Journalists re-examined the case. Court challenges reopened legal questions. Public scrutiny intensified. In 2019, the U.S. Department of Justice formally acknowledged that victims' rights had been violated. The deal, once quiet, became emblematic of systemic failure. Not because laws were broken, but because justice was deferred in the name of expedience. A failure without crime. One of the most unsettling aspects of this episode is that no single illegal act explains the outcome. The collapse occurred through legal discretion, procedural maneuvering, strategic silence, institutional self-protection. This is how systems fail, not loudly, but administratively. What this episode reveals. The 2008 plea deal forces uncomfortable questions. Who benefits from opacity? How much discretion is too much? What happens when efficiency replaces accountability? Who speaks for victims when systems do not? These questions extend far beyond one case. They speak to structural vulnerabilities in justice itself. Transition. The plea deal did not end the Epstein story. It postponed it. And when it returned, it did so under a far harsher light. In the next episode, we will examine how this legal collapse reshaped public trust and why its consequences extended far beyond a single courtroom. This was part 7 of the Epstein files. The 2008 plea deal, anatomy of a legal collapse.